If you close your eyes and picture a courtroom drama, you're probably picturing a battle, right? Two highly motivated lawyers just trying to sink each other's arguments, shouting, "Objection."
Right. And the judge sitting way up high, totally removed from it all.
Exactly, like an impartial referee.
Yeah.
And that dramatic contest, that's the adversarial system. It's the structural bedrock of justice in the common law world. The US, the UK, countries that inherited that legal tradition.
But if you step outside that common law bubble, the whole philosophy shifts.
Completely.
If you go to continental Europe, Latin America, or a lot of East Asia, the courtroom setup is just fundamentally different. It's not about watching a sporting match.
Yeah.
It's more like conducting a coordinated, comprehensive investigation that's led by the court itself. This is the inquisitorial system.
And for anyone trying to really understand global justice, recognizing this philosophical split is the crucial first step.
It really is.
Okay, so let's unpack this. Our mission for this deep dive is to define the inquisitorial system, track its powerful, world-changing history all the way back to the 12th century.
And show you exactly why its existence explains some of the biggest procedural differences you see across global legal systems today.
So, where do we start? The basic definition.
At its most basic, the definition is this. The inquisitorial system is a legal framework where the court, or maybe a specialized part of the court, is actively involved in investigating the facts of the case.
So they don't just wait for the lawyers to present evidence.
No, they participate in the fact-finding process.
And that immediately highlights the core contrast. In our adversarial system, we sort of entrust the search for truth to two opposing self-interested sides, prosecution and defense.
Assuming that the truth will, emerge from that collision.
Right. And the court's role is purely supervisory.
Precisely. In the inquisitorial model, the court is essentially tasked with running the investigation. They're acting on behalf of the state to find the comprehensive truth, regardless of who it benefits.
Okay, but that word inquisitorial, it has some baggage.
It does. It's worth a quick clarification. Some legal scholars actually find the term misleading. They prefer non-adversarial.
Why is that?
They argue it better reflects the modern systems, which are, inquiries. They're not the religious inquisitions of history.
That's a fair point. And structurally, this isn't some minor player on the global stage.
Not at all.
We are talking about the dominant system across huge swaths of the world. Continental Europe, so France, Germany, Italy.
Latin America, countries rooted in civil legal systems, even Islamic law systems like Saudi Arabia, and most of East Asia, except for common law outposts like Hong Kong.
It truly defines justice for the majority of the world's population.
And it usually goes hand in hand with a civil code as the main source of the actual law.
Okay, so given that huge geographic scope, let's drill down into the mechanics. The roles of the key players, especially the judge, must be completely different.
Completely reorganized, yeah.
So if the adversarial judge is a referee, what's the inquisitorial judge? How active do they actually get?
They are the central inquirer, the inquisitor, you could say. In many serious cases, you might not just have one judge, but a whole panel of them.
The panel.
And their role is intensely hands-on. They conduct the questioning, they question the defense, the prosecutor, all the witnesses. They manage the entire file and dictate the flow of information.
So they aren't just sitting back waiting for lawyers to submit evidence. They can actively intervene.
Oh, absolutely. They can demand specific lines of inquiry or even order new evidence to be found if they feel the presentations from either side have been, inadequate or biased.
That suggests a really deep level of institutional trust in the judiciary.
It does, and that trust is rooted in their structural role. And crucially, this fact-finding doesn't just happen during the trial itself.
Before it, you mean?
Yes. In systems like France, you have these specialized magistrate judges, they're known as the juges d'instruction, who participate in the investigation prior to any trial.
And what do?
They assess the police material, they consult with the prosecutor, and they essentially build the evidence file that will eventually be used in court.
Wow. That pretrial judicial involvement is the critical difference. In the adversarial system, the pretrial phase is just the police and the prosecutor. The judge only steps in if a rule is broken.
Exactly. The adversarial referee strictly focuses on rules and procedure. They do not initiate an inquiry.
Okay, but if you want the single most significant procedural nugget that really illustrates this fundamental difference in philosophy.
It has to be how the systems treat a confession.
Yes. This is a huge point of confusion for anyone from the U.S. where plea bargaining, that deal where you plead guilty for a reduced sentence is the absolute engine of the entire justice system.
It's something like 97% of federal cases.
Right. The defendant has to confess. They have to allocute their crime in open court.
That procedural shortcut is essential to the American system. But in a country using a classic inquisitorial framework like France or Germany, a confession of guilt is not sufficient ground for a guilty verdict.
Wait, say that again. If I walk into a French court and I say, yes, I did it, they still can't convict me, just based on that.
That's right. It sounds totally counterintuitive if you're raised in the adversarial system.
It really does.
But the principle of the inquisitorial system is that the goal is comprehensive truth, not just procedural speed. So the prosecutor is still required to provide independent evidence.
Like physical evidence, witness testimony.
Exactly. Something that supports the verdict. The court has to satisfy itself that the material facts are actually proven. The judicial inquiry has to continue.
So the system is structurally designed to prevent short-circuiting that truth-finding process just because a defendant decides to wave the white flag.
It speaks volumes about an institutional skepticism toward simple confessions, maybe viewing them as potentially coerced or just incomplete.
And just to be clear, we're focused here on criminal procedure, right? How a trial is conducted.
Yes, this is separate from the substantive law, which is what defines the crimes and sentences.
Okay, now that we have that contrast clear, let's step back and see how these two roads diverged. I want to go back to the 12th century, before the split. What did justice look like in medieval Europe?
Well, before these pivotal reforms, the legal system was almost universally adversarial. It relied on a formal accusation.
So a victim or a witness or maybe an early version of a grand jury?
Right. One of them had to formally accuse someone before they could even be tried. The state couldn't just launch an inquiry on its own.
And if the state couldn't launch an inquiry, where was the systemic weakness?
The weakness was profound, and it caused justice to stall all the time. Because the penalties for making a false accusation were severe. You could face the same punishment if you failed to prove your case.
So victims and witnesses were terrified to come forward.
Absolutely. There was incredible pressure on the few who dared to accuse, and if no one was brave enough, the system was just paralyzed.
Which is when they'd turn to, what, trial by ordeal or combat?
Exactly. These irrational methods of proof.
Trial by combat sounds like a great TV show, but a terrible way to run a justice system. So how did this massive reform, this shift away from fighting and fire, happen?
The shift was initiated by the church, actually. It was driven by a desire for more rational and effective justice. Pope Innocent III began issuing reforms in 1198.
And what did he introduce?
He introduced the processus per inquisitionem, the inquisitional procedure. This new procedure allowed an ecclesiastical magistrate to summon and interrogate witnesses and try a defendant without needing a formal outside accusation.
That is a tectonic shift in the power dynamic. The court transformed from a passive arena to an active investigative body.
Absolutely. And this new system was codified and affirmed in 1215 at the Fourth Council of the Lateran. This council was critical because it not only formalized the new judicial inquiry, but crucially, it forbade clergy from participating in trials by ordeal or combat.
So it basically stripped those old systems of their legitimacy and religious sanction.
It did.
So the continent embraced the church's rational, judge-led inquiry model. But we know England didn't follow. How did common law resist this shift, especially since 1215 is a huge year for them too?
Well, England's common law was already developing on its own path under King Henry II in the 1160s. His secular courts, unlike the continental ones, kept the older adversarial principles.
And then came Magna Carta.
Right. When 1215 rolled around, the famous Magna Carta served as a profound structural defense against this very new inquisitional power that was sweeping Europe.
That makes the Magna Carta feel like a reactionary document, in the best sense. The famous Article 38 really sums it up.
It does. It says, "No bailiff for the future shall, upon his own unsupported complaint, put anyone to his law without credible witnesses brought for this purposes."
It's a direct rejection of the core idea of the processus per inquisitionem. It demands external, credible witnesses before the state can force an inquiry.
And that simple constitutional protection is why the common law and civil law paths diverge so radically and permanently. But on the continent, the shift was total. The Holy Roman Empire was the first territory to wholly adopt the system.
And they put it in their legal codes.
They did. Landmark codes like the Constitutio Criminalis Bambergensis in 1507 and the Constitutio Criminalis Carolina in 1532.
That deep history brings us to the modern era, the the 19th century, when laws were codified. They cemented that inquisitorial role, but also added limits to protect the defense.
Exactly. And to see this philosophy in action today, France is the perfect case study, especially when you focus on that powerful figure of the juge d'instruction.
The examining judge.
Yes. This figure is the main structural feature used for investigating serious or complex crimes in the French system. Their title, juge d'instruction, literally means judge of instruction or inquiry.
And their independence is often touted as the system's great strength. Why is that structural independence so important?
Because the examining judge is a member of the judiciary, a judge, and therefore independent and separate from the Office of Public Prosecutions.
And the public prosecutor is supervised by
the executive branch, the Minister of Justice. That makes him a political actor, potentially subject to executive pressure. The examining judge is insulated from that political pressure.
which ensures the investigation is impartial.
In theory, yes.
That's a massive difference in institutional trust. The system seems designed to fear government overreach more than judicial bias. But tell me, how often is this powerful, independent figure actually used?
That's a great question, and it gets at a common misconception. Despite their importance, the examining judge handles only a small minority of criminal cases.
Right.
For instance, in 2005, France saw 1.1 million criminal rulings, but only about 33,000 new cases were actually investigated by these judges.
So the vast majority of standard crime is handled directly by law enforcement and prosecutors.
Right. The juge d'instruction is reserved for those complex, high-stakes cases, organized crime, murder, serious corruption.
Okay, so if they are brought in, their investigative duty is truly comprehensive. That's the heart of the inquisitorial pursuit of truth.
It's considered a sacred duty. Their mandate is to gather all evidence, and this is a requirement. They have to seek evidence that is both incriminating or a charge.
And, crucially, evidence that is exculpatory à décharge.
Exactly. They are required to be a balanced investigator, protecting the interests of the accused just as much as the interests of the state.
That's so different from a prosecutor in an adversarial system, whose constitutional duty is generally defined as securing a conviction based on evidence they select.
It is. The French system attempts to put structural neutrality into the hands of the inquiry leader.
And this structural filter must have practical consequences.
It does. If the examining judge finds a valid case after this thorough, balanced investigation, the accused is sent to an adversarial trial by jury.
But the judge who did the investigation
Is absolutely prohibited from sitting on the trial court that tries the case.
that makes perfect sense. You can't be the investigator and the final arbiter.
Of course not.
And the result is that cases with weak or insufficient evidence tend to not even reach the costly full trial stage.
Which leads us back to the plea bargain difference. Since the investigation is so thorough and confessions alone are not enough, the need for the kind of mass plea bargaining we see in the U.S., it just doesn't exist for serious French crimes.
So the system is designed for high-quality, fully voted inquiries to be heard in open court. It's a system that prioritizes the integrity of the fact-finding process over, say, judicial efficiency.
That's a good way to put it.
But, like with all legal systems, very few are perfectly pure. Do we see these two philosophies mixing, creating hybrid systems that borrow elements from both sides?
Absolutely. We see classic mixed jurisdictions, especially where legal history has collided. Think of Scotland. It has a common law, procedural code, but elements of civil substantive law.
Or in North America, Quebec and Louisiana?
Exactly. They maintain civil law principles from their French heritage, but use procedural structures that are heavily influenced by the English adversarial system.
And sometimes, you can even find inquisitorial elements hiding in plain sight in the most purely common law countries.
You do, especially when the goal shifts from finding truth via a contest to finding truth through, say, speed and confirmation.
That's the surprising application.
Right. Look at administrative proceedings in the U.S., particularly for minor violations like the New York City Traffic Violations Bureau.
A traffic ticket?
Yeah. When you go before an adjudicator for a minor traffic ticket, that adjudicator often acts inquisitorially. They'll question witnesses, they might question the police officer, and they effectively take on the fact-finding role to confirm the initial findings before they set a fine.
So when the stakes are low and speed is the most important thing, the common law system defaults to a simplified, judge-led inquiry. It's essentially borrowing the inquisitorial model.
It's a fascinating inversion, and you see this principle magnified in French administrative justice, with courts like the Conseil d'État. Those proceedings are almost entirely inquisitorial, and they rely mostly on written procedure. There are very few dramatic hearings. Instead, the court file is compiled, and the judge requests information back and forth between the plaintiff and the administration until the file is complete. The judge literally builds the case file themselves.
So what does this all mean when we bring it back to our starting point? The idea of a courtroom as either a battle or a focused inquiry.
I think we've established that the inquisitorial system views truth as an objective fact, one that's best discovered through a continuous judge-led investigation that is insulated from political pressure.
Whereas the adversarial system sees truth as emerging from a structured contest of evidence presented by two opposing self-interested sides.
Right, relying on procedural fairness to balance the scales.
And for you, the learner, understanding this fundamental structural distinction explains everything. It explains why a confession isn't the end of the line in France, to why a judge in New York sometimes acts like a mini prosecutor during a traffic hearing.
It's not just a difference in rules, it's a difference in the foundational philosophy of how we trust institutions to discover facts.
Which leads to a provocative final thought, especially concerning the French system's use of that independent examining judge.
The juge d'instruction.
Right. If their duty is legally mandated to gather all evidence, both for and against the accused, does that inquisitorial structure theoretically promise a more complete or holistic truth than the adversarial system?
Where each side is only structurally incentivized to present the facts that support their own argument.
Exactly. It raises the question of whether institutional neutrality can actually achieve a better version of justice than institutional competition.